its lecture series on the topic Constitution, Justice and Access to Justice. Is mediation an alternative? I am Kiran Bhardwaj, advocate on record in the Supreme Court of India and also a mediator in the Supreme Court and Karkadoma Court. And my co-host is Mr. Anil Shrivasta, who is an advocate and a mediator in the Supreme Court. At the end of the session, we will have question and answer rounds and thereafter a vote of thanks by my co-host, Mr. Anil Shrivasta. This is an ongoing lecture series organized by the Supreme Court of India mediators. Besides this lecture series, the Supreme Court of India mediators, along with Commonwealth Lawyers Association, Sports Dispute Resolution Center, and the Youth Bar Association of India, is also conducting another international webinar series on post-COVID mediation, charting the path of the future. And there was also a pre-COVID seminar in the Indian Law Institute earlier also. Mediation is one of the oldest forms of resolving disputes. We can have examples from Indian epics like Ramayana and Mahabharata. It is the most powerful method of resolving disputes. The immense value that mediation imbibes in itself is promoted by MCPC, Supreme Court of India. Further, the pandemic of COVID-19 has made us to change from physical to virtual mediation. The mediation can be fortified by the eminent legal personality, Mahatma Gandhiji's famous quote, which says, "I had learned the true practice of law. I had learned to find out the better side of human nature and to enter men's hearts. I realized that the true function of a lawyer was to unite parties riven asunder. The lesson was so indelibly burnt into me that a large part of my time during the 20 years of my practice as a lawyer was occupied in bringing about private compromises of hundreds of cases. I lost nothing, thereby not even money, certainly not my soul." With this quote, I welcome our esteemed speakers, Honorable Justice G.S. Sistani, former Judge, Delhi High Court, and Mr. A.J. Jawad, mediator, arbitrator, and trainer. I also welcome Mr. Rakesh Khanna, Mr. Jitendra Mohan Sharma, Mr. Rajiv Datta, senior advocates, and Mr. R. Santha Krishnan, former president of Commonwealth Lawyers Association and mediators of Supreme Court, and all mediators, advocates, friends, students, and other participants. Our distinguished guest, Mr. A.J. Jawad, has been a mediator since 2007. He has extensively experience in mediating commercial, contractual, matrimonial, and child custody cases. He is a trainer with the MCPC, Supreme Court of India, and has trained lawyers and judges in mediation all over India, and has conducted training of trainers, that is TOT, workshop for the MCPC. Mr. Jawad is impaneled with the SIMC as an India specialist mediator. He is accredited as a SIMI Level 3 mediator. He is a panel mediator with the Bombay Chamber of Commerce. Jawad is also impaneled as an arbitrator with the Madras High Court. Mr. Jawad worked for ADR, ODR International, UK, a thought leader in ADR and ODR as a mediator and global faculty, and has been involving in mediation training programs in universities in the UK and India. He is a partner and head of ADR service with KD Lex Chambers, a firm offering a range of ADR services. He is a specialist guest faculty with the Maharashtra National Law University. Mr. Jawad has stopped litigation 7 years back, and he has taken total as a profession in mediation. I've got great with this knowledge and great experience of Mr. Jawad. I invite Mr. Jawad to enrich ourselves with his knowledge and experience which would indeed be delighted to have his views on the topic Constitution, Justice and Access to Justice. Is mediation an alternative? I request Mr. Javed to share his views. Mr. Javed, he was our trainer, our guru. So I request Mr. Javed to please share his views.
Thank you, Kiran, for those very kind words. Dear friends, colleagues, seniors, mentors, Justice Sistani, I'm very honored to be here, actually, sharing the platform with Justice Sistani, whose incredible work with Samadhan we are all aware of. I'm grateful to the Supreme Court mediators, particularly Mr. Rakesh Khanna, Mr. Jitendra Sharma, Mr. Rajiv Datta, and Mr. Santana Krishnan and their whole team for giving me this wonderful opportunity. I can proudly say that I've had a role, though a very small and significant one, in introducing them to mediation. And it really inspires me to see the great work that they're doing in taking the mediation movement forward. Justice Sistani was gracious enough to permit me to start this discussion. This actually gives me a little more confidence to address this August gathering, because any faux pas that I may commit will be covered by him. I'm also aware that this talk may be a little boring, but here I would request all of you to please suppress your yawns and listen to me, and hopefully what I have to say will make some sense. So friends, my objective here is to place before you a proposition that mediation is a very apt and much needed mechanism to fulfill the constitutional mandate of providing people with access to justice. For everything, we need to have a theoretical base. Today, if you're flying rockets, it's because of Einstein's theory of relativity. So I will also start by discussing the theory on which our present justice delivery system is based. And then I'll go on to explain how this needs to be complemented by something that is more grounded, more easily understood, and more easily implemented. Now, for this, I have actually drawn inspiration to a large extent from Amartya Sen's classical treatise, The Idea of Justice. Our present justice delivery system is based on the social contract theory that was advocated by many enlightened scholars like Immanuel Kant, Rousseau, John Locke, and this was also articulated by John Rawls in his book, A Theory of Justice. So it is known more as the Rawlsian theory. This theory actually looks at justice as fairness. And it contemplates the establishment of what are called as just institutions, and based on a very unique set of principles of justice. So according to this theory, people's behavior has to comply entirely with the demands of the proper functioning of these institutions. Our constitution is the social contract. If you read the preamble, it clearly says that we, the people of India, are giving ourselves this constitution. Now, in accordance with the social contract theory, it contemplates institutionalized justice by creating the just institutions. So our constitution creates the legislature, the judiciary, and the executive. And we all know what are the roles of these different bodies or institutions. The legislature lays down the law, the executive implements the law, and the judiciary interprets and upholds the law. Now, the law is what defines the right and the wrong and requires that the behavior of the people has to be in compliance with its mandates. In other words, the behavior has to be in compliance with the demands of these institutions. Now, no doubt about it that for the enhancement of justice, these institutions are very important because they facilitate a scrutiny of our values and priorities. Values such as right to life, right to education, right to free speech, right to information, right to equality, so on and so forth. But as Amartya Sen says, democracy is not symbolized merely by the institutions that exist, but by the extent to which within quotes, different voices from diverse sections of the people can actually be heard, quotation closed. Now, what is important and most often ignored is that how does the law really translate at the ground level? How does it influence people's lives? While prescribing what is ideal, does the law also recognize the reality of human interactions, the different dynamics that operate in that realm? Now, take for example, the law prescribes, shares of each family, each member of the family in the inheritance. But it does not provide a remedy for the fissures that may have developed in the relationship. Or to give you another example, let's say that there is a dispute regarding the dissolution of a partnership. The law allows the dissolution of the partnership, but it does not explore the ill will that has developed between the partners. So what we are doing is actually we are dealing with abstract principles instead of real people. Now, the law can also be very confronting to people. If you take a layman, if you ask a layman, decisions based on law may appear to him to be opposed to reason and common sense. Now, sometimes decisions based on law may lead to what may be construed as injustice in a common man's perception. So this brings to mind actually the classical quote from Charles Dickens' book, Oliver Twist. If the law supposes that, said Mr. Bumble, the law is an ass, an idiot. If that's the eye of the law is a bachelor. So a bachelor is equal to an ass and an idiot, I suppose. And the worst I wish the law is that his eye may be opened by experience. Now, in other words, the application of the law, while meeting the requirement of justice from an institutional perspective, may not be seen as complete justice or justice that meets the real needs of the people involved. Now, if you just go back to India's intellectual past, it has been a home to some very powerful traditions that placed more reliance on reason and equity rather than on unreasoned convictions. Now, similar traditions exist in other non-Western societies too, but unfortunately, due to the influence of Western thought on our culture, thanks to colonialism, we have limited our idea of political philosophy and justice to a very westernized philosophy. And in the process, we have made it almost parochial. Now, if you take early Indian jurisprudence, there were two concepts of justice, niti and nyaya. Niti relates to organizational propriety as well as behavioral correctness, which is very close to the Rawlsian concept of justice as fairness and just institutions. Nyaya is concerned with what emerges from the application of niti, how it actually affects people's lives in terms of how they are actually able to lead their lives. Now, this conflict between niti and nyaya is the conflict between duty, as defined by the law, and consequence. Now, duty here represents the institutional expectation from an individual of proper conduct. Now, to explain this conflict, Amartya Sen refers to the Mahabharata. When Arjuna, whom we can call as the consequentialist, he was more worried about the consequences of whatever he may be doing. When he was plagued by doubts about the potentially disastrous consequences of the war, Lord Krishna, we can call him as the deontologist, who was more on the duty part of it, explains to Arjuna that his duty is to uphold dharma by fighting for it. Now, if dharma has to be understood as justice, it symbolizes the niti idea of justice. So Arjuna fights. Now, what happens after the war? When there are dead bodies scattered all over, women wailing and children crying over their dead, one begins to wonder, was Arjuna right after all? The fulfillment of dharma or niti sometimes comes at a cost that is very heavy. So the question we need to ask is, would a more nyaya-focused approach help? To quote Amartya Sen again, justice is ultimately connected with the way people's lives go and not merely with the nature of the institutions surrounding them. So what happened was an alternative theory, which is not necessarily contrary to the social contract theory, had emerged during the same period of enlightenment through a number of philosophers, other philosophers like Smith, Condorcet, Marx, John Stuart Mill. So they adopted a more analytical approach by comparing how institutions influenced people's lives as against people's actual behavior and social interactions. This is called as the social choice theory. Now, this has been developed largely by the work of Kenneth Arrow around about the mid-20th century. Now, the difference between these two theories lies in the contrast between an arrangement-focused conception of justice, as symbolized by the social contract theory and the institutions, or rather the institutionalized justice, and a realization-focused understanding of justice. Now, the realization-focused understanding of justice concentrates more on the actual behavior of people, rather than presuming compliance by all with ideal behavior. The reality we need to keep in mind here is, no matter how proper the established institutions might be, if a big fish can still devour a small fish, it is a failure of justice. And that is what we are seeing happening in society today. I don't want to give any examples. You can understand it if I simply say that, when the interpretation of personal liberty comes, how it can be interpreted in different contexts. The question to ask now in this context is, whether is it enough to just have the basic institutions and the general rules right, or should we also examine how these actually have an impact on the actual lives that people lead? So what Amartya Sen says is, instead of trying to achieve a perfectly just society or social arrangements, would it be more feasible to prevent manifestly severe injustice? The best way, I think, to prevent manifestly severe injustice is to provide people with easy access to justice. Now, with our present arrangement-focused approach to justice, are we able to provide people with access to justice? What should be the kind of justice that needs to be provided? Should it have a purely deontological approach, as symbolized by the very well-known maxim with every lawyer worth his salt knows, fiat justitia ruat caelum, let justice be done, though the heavens may fall, or justice that answers the actual needs of people, not just their substantive needs, but also their emotional needs. Now, what happens if the heavens fall? Nothing remains. So what is the point in doing justice when the consequences are going to be disastrous? Go back again to the Mahabharata, and this is exactly what happened. Now, the realization-focused approach to justice from the perspective of access to justice, in my view, needs to satisfy 5 criteria. 1, it should be cheap. Number 2, it should be fast. Number 3, it should give parties control over its trajectory. We all know that once the party enters an advocate's office, the party loses complete control over what trajectory the dispute goes. So they should have control over its trajectory. 4, it should empower people to determine the outcome. It should not be some third party's decision. They should have the ability to decide as to how they would like to resolve that. And it should respect their privacy. So what we need is a process that, 1, treats people as human beings and not merely as subjects. 2, that provides them with an opportunity to articulate what their real interests are and not merely their positions as defined by some abstract principles of law. Excuse me. That gives them procedural flexibility, control and autonomy, and that fulfills their needs and not merely some notion of a right defined under the law. Here is where actually mediation fits the bill. It is cost effective, it is expedient, It transcends strict legal procedures, so people can really understand what's happening. It provides autonomy. It provides flexibility to the disputants to solve their problems. And above all, it treats people as people and not as subjects to some abstract legal principles. So, in my humble view, it fulfills the constitutional promise of access to justice. Justice that is more focused on consequences and their impact on people's lives, and not just on an abstract definition of justice. So, what we need to understand, and the point which actually I'm laboring to prove here is that, contrary to popular perception, mediation is not just an ad hoc process, which is meant only to clear the backlog of cases. Yes, it is one of the purposes that mediation can fulfill, but it is much more than that. It is a very highly nuanced, sophisticated, and technically refined process that can actually complement the existing institutionalized justice delivery system and help in fulfilling the constitutional promise of access to justice. Justice that is more realization focused, justice that can have a more positive impact on people's lives, and justice that is not based on some notional or abstract principles. So, my humble opinion is that we need to change the whole paradigm of how we understand justice and dispute resolution. And here's the good news, it's happening. Yesterday, while talking to Mr. Rajiv Datta, he said, after 43 years of doing hardcore litigation, I feel it is time for me to take up mediation seriously. So the fact that today we have such leading and eminent legal luminaries like Mr. Datta, Mr. Sharma, Mr. Khanna, conducting these webinars tells us how far we have come. I remember those days when we started mediation. We had to literally beg people to come and get trained as mediators. But today, we have a waiting list running into hundreds, people who are waiting to get trained as mediators. So there's a lot more that I wish to say on mediation from the social justice and conflict transformation perspectives. But Justice Sistani cautioned me yesterday. He said, there's only so much that people can take. So I'll stop here, as I'm sure all of you must be as eager as I am to listen to Justice Sistani. So thank you very much.
Thank you so much, Mr. Jawad, for sharing your immense knowledge and experience on importance of institution, how law translates at ground level, taking us to various theories and making us understand what exactly mediation is. Thank you so much. Now, there's another theory, another definition which says on Baroness Hales of Richmond, while delivering the 6th Sir David William Lecture delivered at Cambridge University, observed, settlement is a fine thing, enabling warning parties to take charge of their own affairs and reach their own solution is a fine thing. Keeping the courts for those who really need them is a fine thing, but I believe that we should aim higher than simply getting cases out of court and towards the goal of finding the method of dispute resolution, which is truly the most appropriate to the parties and to the case. Then there could be no question of alternative dispute resolution comprising the quality of justice. India is a democratic country governed by the rule of law, which ensures access to justice for all the segments of the society. And alternative methods to resolve dispute are necessary to give justice to all in an expeditious and inexpensive way. Now, I will introduce to you one of the most favorite and highly integrated judge with his vast knowledge and experience, Honorable Mr. Justice G.S. Sistani, former judge, Delhi High Court, who studied in the Frankanthani Public School, New Delhi, graduated from Hindu College, Delhi University, and pursued LLB, and was enrolled as an advocate with the Bar Council of Delhi in 1982 and started his legal career with a law firm. Later, he joined his father, Mr. N.S. Sisthani, who was a reputed senior advocate in the High Court of Delhi, practiced law in the High Court of Delhi and the Supreme Court of India. He was elevated as an additional judge of the High Court of Delhi with effect from May 29th, 2016. Though the Honorable Justice Sistani had many achievements, but I am considering here his achievements in mediation. He was appointed as a member of an overseas committee, Delhi High Court Mediation and Conciliation Center in 2014, and thereafter its chairman since 2017 till March 2020, and attended a refresher workshop and basic training workshop in the year 2017, and advanced training workshop organized by Delhi High Court Mediation and Conciliation Center in 2018. He also attended advanced mediation training program held at Pepperdine University, campus USA in 2018. Thereafter, he was appointed as chairman of Delhi High Court Legal Service Committee in March 2019. And its executive, he became an executive member of in 2019. Executive chairman in May 2019. He was appointed as member of the Governing Council of National Law University, Delhi, and as a chairperson of the Judicial Education and Training Program Committee in 2019. His popularity amongst the members of the bar was unmatchably, which was evident from crowd which turned out on the day of his retirement. I would request Honorable Justice Sisthani to enlighten us and give us his views in today's topic. Sir, you have to unmute.
Okay, can you hear me now?
Yes, sir. So before you start, I just want to welcome two persons more, those who have recently joined with us. Yes. I welcome Honorable Justice Mr. M. Imam Ali, Judge, Supreme Court of Bangladesh. Rugal Ferguson, President, Organization of Commonwealth Caribbean Bar Association. Those who are present here also. I welcome all of you. Over to Mr. Honorable Justice Sisthani. Sorry, sir.
No, that's it. A very good evening to everyone. Kiran, thank you for all the kind and nice words. Mr. Javed, it was very, very educative and very nice to hear you. I've been making notes. I'm going to copy some of them and also steal your paper. Well, this is a topic which is extremely relevant. All of us are aware about the docket busting. So, and the clamor for speedy justice. India is often accused of very, very slow wheels of justice. But in the past few years, I have been saying, please don't treat mediation as a spare wheel tire. Mediation is here to stay, and it has been proved. I'm going to quickly touch upon many topics just to give you a bird's eye view of what mediation is all about, how is it relevant today, and compared to our legal system. See, in Delhi, as my friend already informed you, this was in the month of April of 2006 that mediation was introduced in the Delhi High Court. Chief Justice Karju was in Delhi at that point of time. And you can well imagine the opposition by our community, the lawyer community. I was also a lawyer at that time. I got elevated in the month of May of 6. And we thought that if this mediation system is here to stay, we are all going to lose our briefs and we are going to be in deep trouble. So there was a lot of opposition. Mr. Chandyok was the president of the bar, and a combination of Mr. Chandyok and Mr. Karju was great, and the first mediation workshop started in April of 2006. 3 rooms, and now we have 2 floors, and we have a very, very large area. There are about 60 to 70 cases which are taken up every single day. The success rate is about 60 to 65%. And it's a fairly well-established system. The only system in the country which is primarily run by the lawyers. We have a judges committee, but the mediation center is organized and run completely by the lawyers. We have an organizing secretary. Ms. Veena Relly is the organizing secretary. Mr. JP Singh used to be there, Mr. Batra, Sadhana Ramachandran. And we have been getting cases in Samadhan from all over the country, including the Supreme Court. Friends, the historical background has been explained to you. If you look at section 89 of the Code of Civil Procedure, it talks about the alternate dispute redressal forums. We are all very familiar with the arbitrator and arbitration. Then there is conciliation, there is mediation, and now pre-mediation, pre-litigation mediation. And you also have Lok Adalats. My impression was also that mediation is embedded in the heart and soul of every Indian. We have our panchayat system, we have our elders. But when I took my first training, I realized mediation requires training. Although there can be people who are very laborious and who can sit through training after training and can end up to be very bad mediators. Because after all, a mediator cannot be a man or a woman in a hurry. There has to be some element of patience, some element to sit back and listen. So you can't have a mediator who says that I have a matter coming up at 3 o'clock and at 2:30 tell me what is your problem and I'll solve it for you. It doesn't happen. So when you sit for mediation, it's like meditation. You have to come to ground zero. You have to put all your problems aside. Firstly, you should not have problems. We create problems. You must keep them away. And let me tell you, temperamentally you can do that. Sometimes we buy problems. So the idea should be don't buy them. Leave them away. An easy solution is don't stop at my usual dialogue, रेलगाड़ी छोटे स्टेशन पे मत रोको, आधी problem solve हो जाएगी. Keep moving. So what I'm going to get at is, and I'm going to jump from topic to topic, but to bring home one point. See, a litigant goes to a lawyer. First, he mulls over the matter. He discusses with his family, friends, relations, and then he will go to the lawyer finally. Either the limitation is going to end or he's had enough. So the element, he's in a very frustrated point. So our good lawyers don't have much time. So they will quickly say, अच्छा बताओ problem क्या है? क्या चाहते हो? And then, all right, ये करेंगे, वो करेंगे, and your case gets filed. He's able to say half his piece. He wants to say more. But we know the stories are the same. He says, हमें सब पता है, don't worry, हम कर देंगे, तुम फिक्र मत करो. Then he comes to the court. Now, if you go to the trial court, that's a court of numbers. See, they have to give units. So they are also in a great hurry. Then you come to the High Court. With so much of publicity, speedy justice, and speedy justice. So even we have started now becoming very impatient. And we can't blame the Supreme Court because it's T20 there. There are so many matters in the US Supreme Court. 8 judges are there. They sit not even 8 times a year, and here some 30 matters in a year. When we tell them the number of cases are listed in the Supreme Court, they sometimes even faint out of shock. That how can you do this? So this Mr. Litigant never gets a chance. And mind you, some of the men on the lighter side don't even get a chance to speak at home. So where does he speak? So now when the matter comes to court, comes another surprise. We'll send you for mediation. So he's got this completely blank look. I have come to the lawyer. Lawyer has taken me to court. Now this judge sitting there says, I'm sending you to a mediator. I have faith in the Indian judicial system. I have faith in the courts. I have faith in the judge. Now you're sending me to a complete stranger. And I don't know for what. And what is he going to do to me? It's like when you enter the doctor's clinic, he suddenly says, send him for an MRI, and you see a huge machine there. He says, you make him lie under it. You don't know what's going to happen to you. Now, again, there are no explanations. So, friends, when we have embarked upon this system, that's why I said this training business is very important. So, if you're sitting as a judge, you have to explain why mediation. Why am I sending you to the mediator? I'll give you quickly some 3 very odd examples. In school, we had a child who was suffering from paralysis, class 8, 9. The principal was very upset with our class. He said, I'm going to put your class on the 2nd floor. Your friend will suffer. So the class finally asked me to go and request the principal. When I was in college, one auntie called me and said, dissuade your friend from marrying a foreigner. I didn't have the heart to tell her. I was the one who introduced him to the girl. So ultimately she said, if you listen to me, you may be able to convince him. So I told her, if you listen to me, you may get convinced. So to cut the long story short, we said we'll invite the girl. If she likes, she may stay. If you like her, you may keep her. Ultimately, it didn't happen because none of the 3 actors liked each other. In the family, there was a marriage performed in a very close relationship. So जिसको कहते हैं ना सबके मुंह सूज गए. It became a big problem. And the close relation was staying out of town. When I was going to the hills, without telling anybody, I stopped by. I met the uncle. He was quite shocked. Things improved. 3 things were common in these 3 examples. And that is, there were no fist fights. There were no harsh words exchanged. But there was coldness. A cold war. Nobody wanted to speak. So in all 3 situations, people said what they had to. So what I am going to get at very quickly, as my good friend has told you the advantages of mediation, I am only going to add 3 more, which due to paucity of time, my friend did not mention. Although he's a master trainer, he knows everything. One is that it restores relationships. It thaws relationships. And that's a huge advantage, my friends. Whether it's matrimonial disputes, whether it's commercial disputes, or it can be any kind of dispute. How that is so very important is that an example which is often given is in a trademark matter. They found that jeans were being made by a very popular brand. So the court called the parties. They went for mediation. The branded company came up and said, look, the quality of your jeans are so good. Why are you copying us? Relationships were restored. They said, don't copy our brand, but become our supplier. See this great strength of mediation. Look at it from matrimonial angles. Although again, something which I keep saying, mediators, please don't put a band-aid. We have this tendency amongst all of us. You see a husband-wife dispute, you see a child, bachcha ki khatar kathe reh lo. Not possible. First, find out from the man or the lady where the shoe's pinching. Just to give a pat on the back and say, ha, reh lo, bachche ki ke liye reh lo. Gone are the days. You must understand the problem. You must cure the problem. Unless you cure the problem, no mediation. No need to use big words. No need to get into extra training, etc. Have you cured the problem? The lady says the man is a drunkard. Have you sent him to the rehab? He's a womanizer, woman beater. Or his problems. She does not respect my parents. Why? Let's get into it. Let's understand. No, communities are different. See, but once we've worked on them, you ask Kiran, she's dealt with so many of them. When you sit with them, when you explain, you're not a conciliator, mind you. I was getting at section 89 for this reason. Conciliator gets into the problem. He in law can suggest a solution. Mediators don't suggest solutions. We stand by the parties. Most important thing is we listen to them. We say, all right, share your problem. Tell us your problem. So you can't be in a hurry. This is the first time he will hear the problem. I had these two brothers, extremely well-to-do. One was a retired air marshal, the other was a senior architect. One was looking left, one was looking right. So, I mean, they were fighting like absolutely people on the street. So slowly we asked them, what is your problem? All right, let's try and resolve. We were able to have a partition decree. Another two brothers. So I asked this elderly man, just outside, sometimes out of reflex you ask. I asked him, he said, what is the problem? He says, he's 12 years younger than me and he has filed a suit against me. I have treated him like my son. And if he had asked me even once, I would have agreed. So I asked the other brother. He said, no, I told him my children are growing. I need more space. I said, can you request your brother in court once? He says, Bhai Sahab, ab kar lo na partition, aram se rahenge. He says, theek hai, kar lo partition. And I'm telling you, no exaggeration. I passed a partition decree there and then. It took me as much time as it has taken explaining this to you. See, you were able to restore the relationship. And mind you, another aspect, the confidentiality in the matter. See, you don't want everything to come out. Some things you want under the wraps. In court, it doesn't happen. You can apply for any copy, you can get it, you will come to know. But in mediation, everything happens inside. When there is no settlement, you write, it was a non-starter. No prejudice to either side. And if you settle, you don't need to discuss with anybody. Another advantage, besides being quicker, less expensive, less formal, see, the compliance is far greater and much faster. Unlike in a commercial or a civil matter, where the matter will go on for years, and then you will end up with a paper decree. Now you'll start execution proceedings. So here is again a great advantage in mediation, which you will not find in the normal course. Right? Now, besides these, you will also find that during the course of mediation, as my friend explained, see, the parties will give you the solution. They will themselves ultimately tell you that, all right, in this way, if it's a custody case, they will themselves say, all right, this is how we will divide vacations. This is how we will divide the birthdays, Holi, Diwali, etc. And since they have come up with a solution, they know their timings. If both the husband and wife are working, they know their vacations. Unlike, what will the court do? Court will simply pass a line. 15 days here, 15 days there. First 15 days mother, second 15 days father. It may suit neither. Right? So these things are extremely important. And as mediators, you can play a great role. And you can ensure that the parties are able to carry out with this sort of arrangement amongst each other. Now, arbitration is absolutely a formal structure. You end up with an award, then the award goes to court. Prior to the 96 amendment, in our younger days, you could spend the rest of your life getting an arbitrator appointed. That time there used to be section 20 petitions. Then you would file objections under section 30 and 33. The parties who would succeed, they would file a petition under 1417 to make award rule of the court, and it could go on and on and on. In 96 now, the award itself is a decree. So I'm looking at the advantages and comparing mediation and arbitration. Conciliation, of course, doesn't come in any of these. Now, another advantage which we have seen on the practical side is that one settlement can sometimes take care of 5 to 10 litigations. As lawyers, you would be able to appreciate. Again, I'm giving you an example of a matrimonial matter, but it happens even in commercial matters. See, in matrimonial matters, the lady would file a complaint under 498A. She would go to the women's cell. In some cases, they would file a suit for partition. If there's a child, the child would be made a party there. Then you file a divorce petition. Then you will ask for maintenance. And this can multiply. In retaliation, the husband will file an FIR in another state because he wants you to run around. Then he will file some FIR against some other brother, sister, etc. to harass them. So you will have a bundle of cases. One settlement in mediation, and you will knock off 8 or 10 matters. And the other aspect, as a bullet point which you can note, is finality. This is a huge advantage of mediation. If you have settled a matter, not only have you settled those 8, 10 other matters, there are no appeals. So in short, what mediation can do, litigation cannot do. But then, mediation cannot be done in a half-hearted manner. I have had people complaining that, look, the matter went for mediation, and for 3 months it was with the mediator, or for 4 months it was. For that, it's really how the court organizes this system. I know of cases where parties have said we are on the verge of settlement, and the court has said, I'm sorry, I'm passing an order. You did not settle. I gave you 2 weeks or 3 weeks. I don't agree on that approach. But I also don't agree when the matter is let loose. So one side has a ball, the matter keeps getting adjourned. you have to hold the reins tightly. You have to take interest. If both parties say, mediator seized of the matter, please adjourn it. So, all right, where have you reached? On the last date, were the parties present? Was your representative there? What are the broad terms you are discussing? And if you find that the gap is very, very short, then don't send it back. Then you say, all right, I'm putting it the next day. You call your representatives. Let's test it here. And then if you find that, yes, there are serious, then you say, okay, I'm sending you back, but please come back in 10 days. So in short, don't lose control over it. As a mediator, don't lose control. As a mediator, if court sends the matter to you and you find that either of the parties are not cooperating, you send an interim report saying, I listed the matter 3 times. The representative of the respondent did not come even once. Although there is scope for settlement, the court will take them to task. So treat this branch of mediation, as Mr. Javed has rightly taken you through the background, that it hasn't made a lateral entry towards you. It's been there. It's enshrined. It's part of our system. We've neglected it for very long. And the second thing, please don't keep it in closed doors. Even now, after 2006, I've been a judge for 14 years, and thereafter now I'm seeing, I still find that we have not been able to spread this mediation the way it should have been. It can't remain in our rooms. It has to go out. The smell of mediation must diffuse through the air. People must know what mediation is. Whether you have short films, whether you have jingles, whether you hire. See, I'll tell you, talking about the legal aid, when I was this chairman, etc., with our present Chief Justice, we negotiated with the Metro. In fact, Justice Patel negotiated. We launched it. We put in all the Metro bogies with slogans inside over the seats. So people should know. For example, when you deal with prisoners, you should know that their children get free education. Who's going to tell them? So it's our responsibility. See, of course, I have limited office. I do commercial mediations. I'm doing them even now. First, things were different. But if ever, see, which is the correct doctor. You know who's the Hakim. Whether it's Raji, whether it's Mr. Khanna, whether it's Mr. Javed, whether it's Kiran, with any of you. Mediation should not be taken as commercially. In commercial matters, yes. But there are so many other matters where you know that if this matter goes, we've had in court where somebody has come from abroad and said, look, I haven't met my child for 6 months. Or I'm here for 2 days. We've asked some of our mediators that please, you give them time today. Spend 3 hours with them. Come to court at 5 o'clock. Sometimes we've heard matters till 8 o'clock. And there have been success rates. So while we are discussing all these issues, the role of the mediator, friends, you're all trained mediators. Some of you would be listening otherwise. You can't equate yourself, be it integrity, be it all other what you see in court systems. You're the judge for them. You see? So when you first start your mediation, remember all the training. In fact, you must write it down like an oath. Your opening statement. It's extremely important. Like I told you, you go for an MRI. You don't know what he's going to do to you. So you are comfortable when you tell the person, I am the mediator. I am an independent person. I have been appointed by the court. I have nothing to do with either of the parties. I will listen to you. You will come out with a solution. I cannot pass a judgment, but I can help you, right? So the confidence in which you make your opening statement, and when you clear doubts, when you tell the person there is a possibility in caucus that I may hear him and keep you waiting outside, or hear you and keep the other fellow waiting outside. There is a system in it. It's not unusual, right? So what I've tried to do is I've tried to touch various issues, sometimes connected, sometimes unconnected, because like I was telling Mr. Datta and Kiran and everybody, so this is not a full day seminar where we can, elaborate on each point. So we, both of us have, as we had decided, we have touched upon various issues, and these are really food for thought. And maybe someday in good times, we can have a much longer session and take each topic, and both of us can take each topic one by one and elaborate for you, right? So I know there are going to be some question answers. I hope I've not exceeded my time. I may have, I think by 3 minutes, but all the same, thank you, Rajiv, Mr. Khanna, Sharmaji, and all other people, Mr. Shrivastava, Kiran, of course, my co-speaker. He's very, very knowledgeable. He has ocean of knowledge. One day I will sit quietly in his training session and learn some more. So we are open for any question from anyone.
Yeah, thank you so much, sir, Mr. Honorable Justice Sistani, for sharing your practical and realistic experiences and examples, and for taking us to the topics of ADR 2 and showing us the importance of training and mediation. So, sir, now this round is of question and answers. First question which I want to ask is to Mr. Jawad, sir. Whether mediation is a serious process, and what are the development of mediation in India? Mr. Jawad.
Okay. I think Justice Sistani has already answered the first part of your question, Kiran, because he said, don't take mediation lightly. Okay. Now, we have a tendency, undoubtedly, in India to treat mediation as a sort of an ad hoc process. That is also reflected, I was telling yesterday, Mr. Sharma and Datta Saab and everyone, that even if you take, for example, our rules, the priority given to training in mediation is the least, actually. So there is a perception that anybody can do mediation. You can just make people call people, make them sit, talk to them and resolve. It is not so. That is what Justice Sistani has so beautifully explained. It is a very nuanced process. It's a technically very refined process. It has its stages. It has its processes. Mediators need to be, trained in how to conduct that process properly, how to go from one stage to the other seamlessly, so that the parties can really. It is, you are talking to people who are focused on only one perspective. So a mediator has a challenging task, unlike a judge. I don't mean any disrespect to judges. Justice Sistani will certainly agree with me on that. See, what does the judge do? If a party is two counsel are arguing the matter, the judge hears it. According to the law, the judge is going to decide. Okay, but here the mediator's task is doubly, difficult, because mediator has to listen, understand how the parties are looking at the conflict, what are their perceptions, how they feel about it, deal with their emotions, help them to change their perspective, start looking at each other as collaborators, not as adversaries, then take them slowly towards, once he builds up that, then slowly take them towards the process where the problem solving comes, the negotiation comes. And there again, parties may have different negotiation styles. The mediator has to maintain that power balance between the parties, the negotiating power balance. So it is not an easy process. So if somebody thinks that it is something that they can just do for the heck of it, I'm sorry, they are mistaken. See, many times what happens, we do a lot of groundwork in the mediation. Now, parties may not be ready to settle at that time because, but what happens is a month later, The judge who's in charge of the matter calls up and says, you did not settle, but I settled. But what needs to be realized is, because the mediator has put those parties on that path of thinking, of resolution. It didn't happen magically. There was a lot of effort that has gone into it from the mediator's side. That needs to be understood. See, many counsel have called me in failed mediations, have called me 2 months later and said, Jawad, the matter has been settled, and it was thanks to your effort. And I'm sure every mediator has got the same experience. Okay, because it is not just a simple thing where you just said, "Arey bhai, bolo kya hua? Aapko kya chahiye? Aapko kya chahiye?" Aisa nahi hota hai mediation. Okay, you start with an opening statement, you explain to the parties, you build a rapport with them, you listen to them. In the listening itself, there is a lot of nuances that are involved. What is called as active listening. You have to have patience, which Justice Sistani pointed out. Okay, you need to listen to them and give them active feedback, show them empathy, understand where they are really coming from, what is underlying the dispute, what is making this dispute move, alive, keeping it alive. All these aspects are there. So it's not simple. That's what I'm trying to say. The second part of your question is, well, we have come a long way. The very fact that we are having so many webinars on mediation, the very fact that Bar Council of India has come out with the proposition that every law school should have a course in mediation, the very fact that, very eminent lawyers like Mr. Sharma, Mr. Datta, Mr. Khanna, Mr. Singh, Mr. Chandok, all these people are involved in mediation. Okay, Mr. Sriram Panchu. There are so many people who are really committed to this, and they are taking it forward. So it's here to stay. I recall something which one of my friends in mediation told me. Radhika Shapurji said, mediation is an idea whose time has come. So it is here to stay now. Okay, now, but only thing is, just one point I'll add, and I'll stop there. We are still dealing with the surface. We are still dealing with one aspect of mediation, that is the facilitative aspect. Okay, we have not still gone into how mediation can be used in the social justice story, how mediation can be used in the transformative story. It is an ocean. And what I find is it confounds me, because the more I try to read about it, the more I feel there is to learn. There are so many aspects to mediation, and in India, we are dealing just with the surface. Okay, we are just skimming the surface of it. We have not gone, like Isaac Newton said, as he was picking, he said that I feel like a child who's picking up pebbles on the ocean shore while the whole ocean lies unexplored. Okay, so let us keep that in mind, is what my humble request to all those present here. Please carry this message forward. Don't treat it as an ad hoc process. It has got a constitutional basis. It fulfills the constitutional promise, and it has a jurisprudential basis also. It is not a poorer cousin of arbitration the way most people perceive it to be. Thank you.
Thank you so much, sir. Now, Mr. Anil Shrivasta will ask another question.
The question is for Justice Sistani, and the question is, why is that the judiciary is looking at mediation as a means to handle docket explosion and not as a process which brings justice to the conflicting parties?
See, Anil, it's not. That's why I said we started with that. When we talk about ADR,
Sir.
Years earlier, every seminar used to open with this statement. Now we have docket busting. So we must look at this. See, things were very ad hoc. Today, you look at the amendment to the Commercials Code Act. Look at section 12A. There is a provision for pre-institution mediation. See, you look at the Industrial Disputes Act. Look at the Hindu Marriage Act. Right? You look at 432 of the Companies Act. Right? So, 442. See, they all have provisions for mediation. So today you can't say that. Today, everybody realizes that mediators march hand in hand and shoulder to shoulder with any other form of settlement. See, we've always had our systems, but somehow we don't man them properly. See, you had banking issues, you came up with a tribunal. Order 37 was always available to you. A little tweaked here and there, you would not require a debt recovery tribunal. Summary procedure is there. Why do you require this DRT business? Right? Similarly, we have this knee-jerk reaction. Too many rapes, change the law. Arey Baba, don't change the law. Just apply the law. See, what have you done to arbitration? You still had objections. You still have objections. Basic law is not changed. But we've tightened everything. Because when it came to us, we said arbitration, 10 years per hearing. But you have to put in a written statement. I'll tell you, I'll share with you. In one matter, I did not file the written statement for 10 years in the good old days. Because there were many defendants. Somebody A would die, then B would die, C would die. Sometimes service, not service, court not sitting. Today, can you afford to do it? There's a time limit. Look at your objections to the award. 30 plus 90. After that, out. Same is with your written statement. Right? So we are now trying to make things tighter for ourselves. If we had followed things earlier, things would have been different. But then don't compare India to the rest of the world. We have our issues. We have integrity issues. Process server can serve anything and just put a note served. You have a decree, you come back, the court says, sorry, time is over. We have multiple issues. But the good part is now we are all trying. First, we never used to admit. Now, everybody is trying. All the stakeholders are trying. Even lawyers are trying hard. Because people have realized there's no point flogging the same dead horse. You find if you give one client finality, he will come back, he will refer 10 other people. So, we are now not no step motherly treatment to us now.
Thank you, sir, for this
Thank you,
question and beautifully answered. So the next question to Justice Isthani is, there's in the chat, there is a question, sir. One of the, this we have already dealt. Now the another one is, they are specially asking Justice Isthani to tell us how does you compare facilitated contract renegotiation vis-a-vis mediation, through mediation, that is, contract renegotiation.
I'm sorry, I don't understand the question. Mr. Javed,
So the question is that how is it is compared, the comparison between the contract and the mediation, the cases of a contract, and how will we settle it in mediation?
See. Any and everything is possible. Unlike in arbitration, where questions of fraud, serious fraud, cannot be decided by an arbitrator. An arbitrator cannot pass an order of probate, right? See, similarly, in the mediation side, if you are relating to a contract, certainly it would be a case of breach of contract. A may say, I supplied goods. B may say the goods were not in conformity with the specifications, right? So, in commercial matters also, mediation really works. And I'll tell you why. See, it's between two unrelated persons who have no stake. One Mr. Manager will ring up the other chap or write a letter. You did not supply goods on time. He'll say, I did. So there is an altercation. He'll say, I'll see you in court. He'll say, I'll see you in court. That's the end of the matter. But if the two concerned persons were involved, they would understand that with a little bit of understanding, you can ask the person, Arey Baba, tell me out of 100, how many goods did not come on time? How many consignments were not on time? So you say out of 20 consignments, 17 were not on time. You say, all right, you pay me for those 3, we'll come to those 17 later. Or vice versa. See, therefore, when parties meet during mediation in commercial matters, there's a lot of success rate. Because people who are at the helm of affairs, they have no sympathy to the cause, no? The company will pay. But when the real person is involved, he said, why are we fighting? Arey Baba, don't give me 18%, give me 14%. At least give me my payment. I will take 14, I will take 12. You want installments? All right, take installments. So even commercial matters, there is a lot of scope in mediation. I hope that was the question.
Thank you so much. Thank you so much, sir, for giving a information which is really worth. Next question, Mr. Anil will ask.
This is a question for Mr. Jawad. What are the social and economic advantages of mediation? Social and economic advantages.
I think Justice Sistani has already covered all those advantages when he spoke. See, the social advantages are, one is you don't, it's a question of conflict management at different levels. Because you don't allow the conflict to escalate to a level where the parties become destructive. So you're able to deal with the conflict in such a way that the parties are able to look at the problem as a mutual one and approach the problem as collaborators to mutually see how they can solve it. Okay. That is the social advantage of that. Now, supposing there is, see, each conflict has its, what should I say, its impact on society in the sense that it affects a large number of people, whether it's a matrimonial conflict, whether it is a commercial conflict, it impacts people. Okay. So that impact can be substantially reduced by resorting to mediation in such a way that there is very less rancor, there is very less animosity between the people, and you try to address the problem as a mutual one that needs to be resolved. Now, the economic advantages, one, it is very fast. It is as fast as the people are able to come to terms with each other and able to reach an agreement. Okay. So definitely they save a lot on money. And there's no question of the dispute dragging on and on endlessly. Okay. So all they have to do is sit together and talk to each other with the help of the mediator. It may be resolved maybe even in one day. We have resolved disputes we have sat in the morning by 11:30 and resolved a dispute by 4:30 in the afternoon with a lunch break of 1 hour. So imagine the savings there. Imagine how much from the economic perspective, supposing if you're fighting a case in the court, you're going to be losing time. You have to, take leave from your office, keep traveling to the court, spend the whole day over there. And now, particularly with online mediation, it has become so easy. I was recently mediating a matter. This lady was given the option of either having a face-to-face mediation or an online mediation. She preferred online because she had a 2-year-old baby to look after. She said, "Sir, I have attended face-to-face mediation earlier, and I was finding it very difficult. I did not attend because I couldn't travel to the court. I couldn't go there and wait for the pass, go inside, do all that stuff. Now I'm able to sit at home. I'm able to look after my baby at the same time attend the mediation." So you see the advantages that it provides for you. So definitely there are both social and economic advantages. So the more you want me to talk, I can go on giving you example upon example, but that will take a long time. So I'm sure you don't want it. And I think what I have said should be enough to cover along with what it is only supplementary to what Justice Sistani has already spoken.
Thank you.
And thank you, Mr. Jawad. The last question I will ask Mr. Honorable Justice Sistani. Sir, these days, almost every contract has an arbitration clause. How can a mediation clause be introduced? One. Another, along with it is, can you compare mediation to private arbitration as well as international arbitration using universal rules and New York conventions, etc.?
See, Kiran, these are multiple questions. First, let me start from the end. We can't mix the two.
Yes, sir.
Although there is a concept of MEDAB now, right? But the moment you cross the Lakshman Rekha, like I was doing a mediation, and at one point of time, they said, "Gee, for this point, you become our arbitrator." I said, "I'm sorry, that can't happen." That will be absolutely incorrect. It will be improper, right? So there can't be any comparison. Yes, the arbitrator can look at the problem. He can, at the very outset, say, look, you can examine it from this aspect. The parties can say, now that we've reached here, they talk. Sometimes, see, the forum becomes informal, no? The moment the forum changes, the parties are able to sit. Although Mr. Javed will bear me out, we've had cases where the parties have said we will not sit in the same room. They would come from the same house, but in different transports. So after 3 hearings, I used to tell my DB partner, my first aim would be that they should travel in the same car. So relationship must thaw. Because when, see, it's like a witness. You ask him a question, he answers. Then he volunteers. So when you take a person to that level, then he'll start saying many more things. And that's the time things are going to become better. So rules don't apply. These rules, the unsettled rules will not apply to mediation. That's for sure. And it can't apply for international arbitration either, because it's an arbitration. It's not a mediation. You can appoint an arbitrator and tell him to mediate, then he won't remain your arbitrator. But during the course of arbitration, if at the very initial stage parties settle, then you can bracket it in a case of MEDA. It's a concept. It's known, well known now. You had many seminars on this. So similarly, rules of international arbitration, I mean, I must share with you, the whole aim of arbitration was simplicity. But I think it's become one of the most complicated laws. Parties A, forum B, laws C, seat of arbitration D, objections E. I don't know, all the learned senior counsels will be able to, I think one day they must sit and tell us about all this. This convenience, I mean, I really don't understand. How do you call it a simple, what was the aim of arbitration? And you know, we've given arbitration a bad name. Again, I'm digressing, but let me tell you. You know, some of the most successful arbitrations are done, you know, by whom? Motor market. The president of the motor market will be the arbitrator. He knows everybody. He'll say, Mr. X, मुझे पता चोर है. He'll say, इनका माल दे, नहीं तो कोई मार्केट में तेरे से माल नहीं खरीदेगा. Successful. Cloth Merchants Association. Paper Merchants Association. See, what is the objective? The objective was no going to court, no court fee, no lawyers, no time taken, no executions. Implementation, what was implementation? It was like desh nikalna, biradari se nikalna. In the motor market, if one fellow takes up hundis, etc., and then doesn't, I'm talking through experience, huh? Or cloth merchant, bill के पीछे लिखा होता है. But उस वक्त प्रेसिडेंट भी बड़ा इंटेग्रिटी वाला होता था. वो पैसे खर्च के प्रेसिडेंट ही बनता था. वो जो वाकई रिस्पेक्टेड आदमी होता था मार्केट का, वो वही होता था. उसके पास जाते थे, लाला जी, शाह जी, देखो ये हो गया है, इसको बुलाओ, मेरे को पैसे नहीं देगा, लड़की की शादी आ रही है, ये हो रहा है. इनसे अभी बुलाते हैं, 4 बंदे और बुलाए, भाई क्यों नहीं दे रहा पैसे? कह रहा जी मेरा ये हो गया, वो हो गया. अगर जेन्युइन लगा, अच्छा चल तेरी किस्त बांध देता हूँ. जेन्युइन नहीं है, तू दे, नहीं तो मार्केट में तेरे को कोई माल नहीं देगा या लेगा. Right? See, this was the objective. And where is it gone? So we have very good systems. आप बताओ मुझे क्रिमिनल मैटर में जो जेन्युइन रेप केस होता है उसमें किसी को बेल मिलती है? अखबारों में जो मर्जी बोलो. I don't think our system allows anybody to go scot-free. But then today what happens? Today POSCO is used to teach anybody a lesson. So what do? We dilute our own laws. They say nothing. I've seen it in matrimonial matters. I've seen it where tutor asks for fee in a jhuggi jhopdi thing. First they don't pay for 3-4 months, then they say, no, this guy did this to the child. You know where the laws are? What happens to the man? So we have everything. Use, don't misuse. So I don't know whether I've answered what the question was.
But very good examples also along with it, sir. Thank you so much
Yeah.
for your immense knowledge and practical experience also, sir.
Right.
So now I will request to deliver vote of thanks to Mr. Anil Shrivasta.
Thank you, Kiranji. It is my honor and privilege to propose a vote of thanks on behalf of the Supreme Court of India mediators for this engaging and informative webinar on the topic Constitution, Justice, and Access to Justice. Is mediation an alternative? We thank Justice Sistani for sharing his views on the topic of today's webinar. Justice Sistani has very candidly stated that mediation should not be treated as a spare wheel. It is relevant and very much here to stay. According to Justice Sistani, mediation is embedded in the heart and soul of every Indian, but mediation requires training. It requires tons of patience. It requires the ability to sit back and listen attentively. In this aspect, according to him, mediation is very much like meditation. Justice Sistani has also highlighted the main advantages of mediation, which are that it restores relationships, there is confidentiality in the matter, the compliance in mediation is far greater and faster as opposed to that of a court case. One settlement at times takes care of 4 or 5 cases between the parties, and we have seen this many times in matrimonial matters especially. And most important, according to Justice Sistani, mediation lends finality to the dispute. Thank you, Justice Sistani, for your thoughts. We mediators go back today a little bit more wiser and certainly a little bit more knowledgeable. I also take this opportunity to thank Mr. Jawad for tracing the jurisprudential basis of mediation from the theory of social contract to the Indian jurisprudential system based on Niti and Nyay. Mr. Jawad has brought out that access to justice means that justice must be cheap, it must be fast, the parties must have control over the dispute trajectory, it must empower people to determine the outcome and respect their privacy. These parameters, according to Mr. Jawad, are met by mediation since it treats people as people and not as some abstract principles of law. Mediation, therefore, according to Mr. Jawad, meets the constitutional goal of access to justice. We thank Justice Sistani and Mr. Jawad. We also thank Justice Imam Ali, Judge of the Supreme Court of Bangladesh, and Mr. Ruggles Ferguson from the Organization of Commonwealth Caribbean Bar Association for participating in today's webinar. I thank all the participants for joining us in today's webinar, and your constant messages, queries, and observations on the chat box are a testimony to your eager participation in the webinar. We eagerly look forward to your participation in our future lecture series. A special thanks to Rahul and his entire team for providing us the technical assistance and expertise in organizing this webinar and helping us come together on this platform. Thank you all once again. Have a very pleasant weekend.
Thank you. Namaskar. Jai Hind.
Thank you.
Thank you.